Yes, you can be recorded in public with or without your permission. But what about searching through those records? Second, plaintiffs seek to enjoin the warrantless use of the learned database. After all, the Fourth Amendment is supposed to protect us from unreasonable searches. What is the reasonable justification for an exception to the warrant requirement? Is it just because law enforcement has already collected that data? Once again, the courts place the desire of law enforcement above the rights of the people. However, the complaint does not allege any facts indicating a substantial risk that police will soon retrieve plaintiff's license plate information from the database. So it's okay if the police infringe on your rights as long as there were no facts presented that there was a substantial risk they do so beforehand. I don't know if the judge was simply obtuse or outright biased, but her explanation of this substantial risk is laughable. Indeed, plaintiffs do not allege that they will soon commit or be victims of any of the offenses enumerated in the Expressway Camera Act, namely vehicular hijacking, aggravated vehicle hijacking, terrorism, motor vehicle theft, or any forcible felony. The purpose of the warrant requirement is not to justify a reasonable search, but to prevent an unreasonable one. I'm sure if the plaintiffs were victims of a hijacking or vehicle theft, they would find it reasonable to search the ALPR database for their vehicle. But what about searches for other reasons? Say, an abusive husband or boyfriend trying to track down their victim, or an officer on a hunch or vendetta that wants to surveil a suspect but cannot get a warrant. Couldn't they use the ALPR database to grab pictures wherever the suspect vehicle travels? After all, couldn't an officer simply list them as a hot plate without any probable cause? The court went on to make a rather interesting argument about searches. The Supreme Court has developed two distinct paths to identify a search. First, under the property-based approach, a search occurs when an officer enters a constitutionally protected area for the purpose of gathering evidence against the property owner. Alternatively, under the privacy-based approach, courts ask whether a person has a legitimate expectation of privacy in a given situation. Because plaintiffs do not argue that the ALPR program involves a physical intrusion on their property, the court will examine the Fourth Amendment challenge under the privacy-based approach. The court, apparently in an attempt to justify this violation of your rights, points out that since ALPRs do not physically intrude on your vehicle, you have no expectation of privacy as defined by the courts. They seem to ignore the fact that when an officer enters a hot plate into the database, the government is searching for the effects of a private individual for the sole purpose of determining where this person may logically be.